2, 1, go. Government mirrors a prosecution who has evidence that is exculpatory and follows the Brady Rule. Why so? Four things on their case that benefit our side, and these are the necessary flips that prove why they're wrong. Firstly, they talk about wanting to provide the best representation to their client. Problem: if you're allowed to withhold important information that is part of the court, you cannot properly represent your client because of three reasons. One, as a prosecution, there also needs to be a compromise between representation and the realistic goals of the court, which can benefit all parties while pursuing justice, which means two, you represent an echo chamber incentive with your client, which is already a skewing of the decision-making process by allowing empirical evidence to be omitted to ensure a non-objective decision, which means three, you not only break the constitution by withholding due process from court, which everyone is entitled to do so, but doing so disables your client from reaching an objective decision, which destroys the representation case. This was the bulk of PM's discussion that is effectively destroyed coming from my speech. But then secondly, they talk about extending the process and making it more quote-unquote bureaucratic. This is where debaters need to understand that just because you throw around typical suffrage phrases like bureaucracy doesn't mean it's a harm, because this is also part of the incentive due process in order to provide justice, the bureaucracy, which are much higher obligatory principles to fulfill for a court rather than having to diminish bureaucracy as a judge. This makes no sense. In fact, the solution to bureaucracy should not be to forsake any necessary steps to justice and fairness, which means that if you wanted to speed up the process, you probably get better lawyer pipelines, fund investigation bureaus better, and allow for the justice system to uphold the reputation of justice if they want their highly politicized position to stay reliable. How do you do this? By allowing all information to be inside the court. In your side, when you don't have the Brady's law to be able to be pushed as an obligatory measure, people can decide to withhold information, which makes the justice system unreliable in their side. Thirdly, the prosecutor is more burdened than in power coming from the entirety of government side. First of all, with great power comes great responsibility. If you have higher power to investigate, this is a fact because you are a prosecutor and this is literally part of your role, then of course you have the burden to lay out all information you get. I don't care if you don't think this is not real because this is real. This is because defense investigation is not state supported, which is why the Brady Rule is implemented. Their response, which is extremely late on WIC by the way, is they say that public defenders exist and suddenly they have all the access to police. Quick law lesson: public defenders do not have a police force. Prosecutors have police. This is because when you listen to courts, it is called the state versus X person. The X person is still representing a private person, while the person who is the prosecutor is representing the state. Hence why the state has the capacity to be able to allow the police to push for investigatory procedures under the prosecution. For defenders, they still need to depend on private investigators because they do not have the police because they're not representing the state. Especially when defender offices often have tons of cases because a lot of defenders do not want to fight unwinnable cases, which means, and this is the flip to their case, that procedural investigation for defenders is worse, which only proves this is false. They question why then a prosecutor is responsible for solving the inequalities inside the court. The problem is, they're not burdened to equalize the court. All they have to do, very simply, is to lay out evidence that was withheld because it is their burden as people who have much more power as investigators to also lay out the investigated evidence. So if government talks about ruining the reputation of prosecutors in worst case, maybe what you should do as a prosecutor is to not withhold information in court. These are just the consequences of your actions. Fourth, they say you have to retrial or reopen cases and reopen traumas. Panel, this rule allows people to solve it inside the case by obligating maximum evidentiary layout rather than wait for evidence to spring up in defense side after, let's say, for example, post-court investigation and having to reopen traumas via retrial inside government. This is the very important discussion that government tries to deliberately lay out, especially when defense, stop badgering me, especially when defense quality is dependent on laid out evidence coming from prosecutor evidence, that you monopolize narrative control to prosecution. In fact, we say that in the worst case where a retrial happens on our side, we say this is fine because this retrial is allowed under due process and justice because all information is laid out in the trial. In your side, a retrial happens under a lack of information in court, which is the worst hit to the trust to the judiciary system than baseline retrials ever had. This means that if their case was on reputation to be able to allow people to trust the judiciary system, we have that better because people understand that the judiciary system is now obligated to allow a lot of these informations to be laid out in the court rather than in your side where you're trying to, let's say, for example, accept the fact that some of my evidence will not be part of court, even though that evidence is supposed to help the court decision. So if the case was that the judiciary system is better, hence we do not need the Brady Rule, that better system on progression comes with the Brady Rule, which proves why PM is wrong. The Brady Rule is one of the innovations in the judiciary system that ensures proper evidentiary support for cases and discussions. Hence, logically, impeding the obligations of the Brady Rule is also impeding the existing betterments of the current judiciary system, which proves why they fail in government side. Before I move on, sure, POI.
if prosecutors are inherently bad, why is this obligation suddenly enlightening them and then they're not withholding information? But on your side, why will they not withhold serious evidence and give out less evidence just to show that they're following the Brady Rule?
I don't care if prosecutors are inherently bad, right? This is a response to Whip's last discussion, framing prosecutors as people hiding evidence. Surprise, surprise! If they don't hide evidence, Brady's law does not become relevant in the court, which means that this only applies to prosecutors who are hiding evidence. Notice, this is why we're talking about prosecutors who are bad, because these are the only people who are cared about in the Brady's law. What did Op tell you? 3 facts, not just squirreled mechanisms, and this is where I emphasize that I'm merely citing the law. 1. The state, especially prosecutors, have higher power in investigations because they're representing themselves in court. This was already explained by my first 2 speakers. 2. Defense quality and or capacity to investigate is only dependent on defense incentive, i.e. paid money and existing connections which are lesser under private individuals because no one knows who Brady is. But third, that absent the Brady Rule, the police and the executive and judiciary branches can forward their incentives and withhold evidence which have been a major proprietor for oppressive and abusive acts uncontested inside opposition, racial profiling included. This is how our arguments are justified. You get better accountability and you allow proper mediation of court decisions by gaining widespread judicial trust as well as most possibly understanding the situation better, which means you don't get a skewed perception of justice that happens inside government. 2, you're also able to mediate the current political and evidentiary imbalances in court by ensuring all information is laid in court, lest they get a Brady violation, which almost ends up always in a cold clause. All of this falls under obligation, which is the last argument and the thing that government fails to discuss, that you are constitutionally obliged, and this discusses the obligation to uphold justice and follow due process, and this only happens when you fulfill your role as the prosecutor by gathering and laying out evidence. And by the way, unlike their side, I weighed everything they talked about. It was very important because if they had withheld all the information about their case, probably me or you as judge wouldn't be able to weigh as a panel as well. It is important to have all the information to be able to understand and create critical decisions. Proud to oppose.